we need to look at our first interactions with the jurors as being maybe the most significant interactions there are in a trial. And the benefit that we have as plaintiff's attorneys or prosecutors in the criminal settings is that we get to go first.
Welcome back to the jurytrial.com podcast hosted by Trial Lawyers of Wisconsin, myself, Mike Karp, and my partner, Bob Welsenbach, where we talk to some of the most talented and successful trial lawyers in the country. Today, we have the pleasure of speaking with Sharif Gray and Gray Broughton, who are out of Virginia. They have a lot of 8- and 7-figure results. Most recently, I think we've all heard about the $20 million verdict on behalf of a 13-year-old boy who was abused at a psychiatric residential facility. I will let them talk at length about it, but today we'll be focusing on opening statement. For those of you who know anything about the case, they had a pretty unique approach to opening statement that I think was highly successful. So thanks, guys, for joining us today.
Yeah, thank you for having us. It was cool to meet up with you guys in person and now to see you on the podcast.
Yeah, thank you.
So just to get started, for anybody who hasn't heard about the verdict, if you could just give us a quick breakdown of kind of the general facts of the case.
Sure. Yeah, Gray Broughton here. So this is a case that came to us about a couple of years ago where we weren't the first choice of the father of the 13-year-old boy. He contacted some larger law firms and had been turned down. This is a case where there really weren't any economic damages. Our client was a young man, 13 years old at the time. He was a resident at a psychiatric residential treatment facility. It was during COVID. He was staying in a dorm, and there was a caregiver who was actually one of his favorite caregivers who came into the dormitory where he was living at the time. And things escalated. Ultimately, she ended up pushing him down several times and then dragging him across the floor by his shirt, which got wrapped around his neck during that process. And then she deposited him out into the hallway by himself, where he then, he had a history of self-harm, where he then tried to strangle himself with his own shirt. This is all captured on video, at least the portion where she pushed him down and then dragged him across the floor. Interestingly enough, when he was out put into the hallway by himself, there was video of that as well, but it wasn't preserved by the facility and it was ultimately taped over after 30 days or however long it was. So we could talk about that later, but that ended up being a key part of our strategy in the trial as well. But that's kind of a nutshell of the facts of the case.
Got it. And just so I make sure I have my facts right, this was about a 3-day trial, 4-day including jury selection?
5? Well, 5 including jury selection.
Yeah.
Okay.
So on the last day, basically the jury got the trial, got the case on the last day. By the end of Thursday, everything had been done, closing arguments, all of that. And so then Friday morning, jury got the case.
And how many witnesses did you call in your case in chief?
We had 4 lay witnesses. They had 14. And 2 of the 14 were experts.
2 of them were medical doctors.
That's right.
Got it. And the damages were all non-economic, correct?
Correct. Yeah, we didn't necessarily make the decision to waive because there wasn't it. I mean, the treatment in this case was a packet of Neosporin. That was it. I mean, the physical injuries were bruising and a couple scrapes on his arm.
What about any therapy after the fact?
So no therapy. He was already, because he was already receiving therapy because he was a resident in a psychiatric residential treatment facility. There wasn't any specific additional therapy or treatment that he received. And in fact, it wasn't necessarily our first choice to go without experts, but we actually retained a psychiatrist to look into the case, to evaluate our client. Met with them. We spent tens of thousands of dollars going through this process. But the issue that we had is that he had all these diagnoses prior to the incident, and then those diagnoses did not change as a result of this incident. So we were sort of hemmed in terms of not being able to put on the traditional experts or have the traditional economic damages, or show this life care plan was going to be needed, and that he was going to require all these different treatments as a result of this particular injury. Unfortunately for this young man, he had a horrific childhood, starting around age 4, and things were not good for him up to this incident, and certainly the incident, the attack did not help him in terms of his trust and things of that nature. But being able to say, well, he had these diagnoses before the attack, and then after the attack, he had all these additional diagnoses. Just that wasn't something that was there for us.
Yeah. So you guys mentioned another lawyer or some other lawyers had looked at it, and I know we're talking about opening statement today, but when we take in a case, we're always thinking ahead to what, how is this going to present to a jury and voir dire, and kind of work it from backwards. What was it that the other lawyers thought that there wasn't the case, and why did you guys think there was something here? What was it about the case? Considering no economic damages, what was the plan?
Yeah, so this case came on before Sharif had even joined the firm. So Sharif wasn't involved. I was the only attorney at the firm when the case came in. And at the time that I brought on the case, we didn't have the video yet. I just had talked with the father. He explained what he had seen on video during part of the criminal process, and there was, I think probably the other attorneys who passed on this case heard there's no treatment, there are no economic damages. He had a history of all these different problems before this happened. He still had those problems. There wasn't necessarily anything that had changed that much. So I think probably from other attorneys' standpoints, there wasn't a lot there. There just wasn't the traditional, let's take these economic damages, multiply them by whatever factor we decide. If you're taking zero and you can take zero and multiply by 1,000, and you're still at zero.
Did the other law firms have an opportunity to review the surveillance video?
No, I have no idea. I don't know which particular law firms he had contacted before.
Gotcha.
But no, so we got it. It was described to me. I then later, after he'd retained us, I then later obtained the surveillance video from counsel for the facility, and so I assumed that they didn't have the chance to review it either.
So is it just a straight rejection? Nobody had it before you guys?
Correct.
Oh, wow. Okay. I saw an email this morning from Trial Guides shouting you out, Sharif, and I was reading through it, and it mentioned that you've been inspired by Nick Rowley, Keith Mitnick, and others when you're coming up with your framing for opening and just your philosophy as to how you put together a case and work it up. I'm curious, because I know for myself, the way that I put together my openings it's changed a lot since I started trying cases. Could you just walk us through kind of your mindset, your approach, and maybe how that differed from when you first started trying cases?
Yeah, so we're all told, or at least taught, kind of when we're going through law school, that the case is all about the closing argument. It's right. You make sure you look at the jury instructions, make sure you have the evidence to prove up your elements. Kind of, if you're going to do anything first, write out the outline to the closing. it took some time, but over the years, I have learned that that's backwards, at least in the work that we do, in the sense that, like, if we can accept the fact that people and jurors are people, right? They cannot just remain impartial until the judge says, now you can talk and think, right? If we accept that as true, then we need to look at our first interactions with the jurors as being maybe the most significant interactions there are in a trial. And the benefit that we have as plaintiffs attorneys or prosecutors in the criminal setting is that we get to go first. And so we get to put a lens on, or at least we get to try to put a lens on, a frame on the evidence that we hope will be adopted later by the jury. And so seeing just some really incredible trial lawyers do that time and time again, hearing over and over, it's about opening statement. It's opening statement, opening statement, opening statement. And of course, in conjunction with voir dire, and Nick Rowley, I've even heard him say it's voir dire, it's opening statement, and it's your first witness, because then you at least have somebody who's giving you some credibility to what you just said, right? Or tearing down whatever the defense just said in their opening. And so it all comes back to, if you can accept the premise that the people do not stay unbiased or truly impartial until the end, well, then we need to put all our effort at the beginning. And so that, for me, has changed how I and how our firm approaches cases. When we're preparing for trial, and really now what we're doing, or at least we're trying to do, is when we're preparing our cases really at the outset, like we're talking still in early on in litigation, we're asking the same questions that are ultimately going to be used to frame what our opening statement is. And it's been a game changer. It really, really has. And it's eye-opening too, because it just isn't the traditional way in which people are taught. But I'd be lying if I said, oh, this is some unique method that we came up with. No, one of the consistent things that you see around the country with people getting great results is you see people taking the opening statement very, very seriously and using it as a roadmap, more so than a roadmap, but an outline of the entire case.
Yeah, I think we talk about that a lot too. And I know some lawyers say, well, you should leave some surprises for witnesses to come in. And I think our view is we want to kill everything in opening, as much as we can, and just get it all out there, because, sometimes your witness order changes and who knows when that information is going to come up. And I think what you just said, which is, I think these people are pretty biased and they decide early on who they're going with. My view is you don't want to wait for 3-4 witnesses. They might have already made up their mind after opening statement. So what's your guys' thought on that? Do you leave things purposely out of opening for it to come up spontaneous during the trial, or what? How do you approach?
I mean, I don't. I've heard lawyers talk about leaving things. I mean, also it's a trial, so as you guys know, like, things are going to happen you didn't expect, right? And so we'll take advantage of that when it happens. But I'm a big believer, if I can get our entire case out and opening, I'm doing it, right? And there's a really famous I guess he was a trial lawyer. I think he was with the Manhattan DA for a long time. He was a very young federal judge. His name is Herbert Stern. He wrote the book with a professor named Steven Salzberg called Trying Cases to Win. It's like a 5-volume set, way too long for me or any normal human to read. They've got like a 1-book condensed version. So like the whole set condensed or abridged into 1 book called Trying Cases to Win. It's fantastic. And I remember when I was in the Army doing criminal defense work, I found that book and I got so excited that I would spend, I'm a nerd, so Gray's not surprised by this, but I would spend my Saturday mornings just summarizing every chapter of that book. And the premise behind that book was the same thing that we're all talking about. It's opening. There's a video on YouTube by this guy. His name is Herbert Stern. If you go into YouTube and you Google or you type in Herbert Stern, like opening statement, I think maybe basic building blocks, and he gives this like analogy of trying to prove why opening statements are so effective and important. And he talks about a football game. He talks about how, like, let's say there's 2 people, you're both rooting for one side or the other, watching this football game, and then suddenly the ref throws a flag, says, hey, there's holding. There's a you're like, no way, there's no way that's holding. Your buddy's like, yeah, that's classic holding. They then play the replay on the big screen. You haven't changed your opinion. You're like, you're not changing. Your buddy's still adamant. It's like, yep, that's a clear thing. Definitely, whatever, not holding or whatever it was. And the point that he's trying to make is that, one, that people don't wait till the end of the game, right? Of course, to make up their minds about who they want to root for. But two, even in the face of what some would argue clear evidence, once you've made up your mind, it's no longer just a battle of like who's right. It's also a battle with yourself, your own ego. If I have decided as a juror at the beginning of the case that I think this side is right for these reasons, for me to now not just change, for me to change my mind, I don't just have to, it's not an easy switch, right? I have to recognize that my prior decision was actually incorrect, which makes the ego involved, which when the ego is involved, good luck changing that. So again, that's all the reasons why to really, really emphasize getting everything out there with your opening statement.
I think one of the more challenging components of opening statement is the undermining section for me. And that's because if we think about, I know you guys are really into case framing. I think about case framing as a heat map. And essentially, the question is how much time is the jury going to spend paying attention to the different parts of the screen? Where are they going to be looking? What are they going to be focusing on? And what are we telling them the case is about? So when it comes to undermining, I think really good trial lawyers you develop a skill of anticipating the defenses. And sometimes you're so good that you anticipate defenses that are better than what they come up with, right? But you don't know exactly, in some cases, maybe you have more confidence about what they're going to say. Other cases, you're kind of guessing what they might be going up there and saying. And of course, then after your opening, it may change dramatically and they may abandon a lot of the things they were going to say. But one of the things that I try to focus on is, okay, am I going to choose, the top 3 defenses that I think I need to put into context right away? Am I going to try to address everything? And there's this balance of trying to get ahead of everything they might say and then spending too much time and too much attention on the defenses themselves, which makes the case kind of a coin flip. Like it makes the case complicated. So in a case like this where, and I encourage everyone, if they haven't watched the TLU breakdown or they haven't seen the YouTube video where your entire team broke down the verdict for 3 hours, which I watched several times and thought was amazing. Could you just explain your approach in this case to addressing the defenses and kind of how that played out?
Yeah. So for context, we have a 4-question framework that we use for our cases and for opening. The first one, and I pulled it up just to make sure I don't screw it up, but the first one is, why is the case important to the jury? And ultimately that's the community's expectation. The second one is, we're going to get to exactly what you're talking about here in a second, but the sequence here is important. The second one is, well, what was the trust that was betrayed? The third one is, what was the universal value that was taken, right? It's not, for example, it's not about the broken foot. It's about the loss of autonomy, the loss of hope, dignity, trust, whatever, right? That's your damages. And the fourth one is the why are we at trial, which is people have different phrases for it. You talking about when the portion of the opening where you're undermining the defenses, the Keenan group calls it, what is it? The swift boating the defenses. And I'm sure Mitnick and his team would say it's giving it the appropriate context or the appropriate packaging. We went to a training of his not long ago. Actually, it was last week. Wow. And the time was crazy. But anyways, it's the same thing. And so typically what we do is we try and isolate 3. And so why are we at trial question? So we're at trial because clearly there's a dispute. For this specific case, ultimately, we believe that there were 3 main defenses, 3 main reasons we were not agreeing with the defense, 3 main reasons why we're at trial. The reason number 1 was they believed that the caretaker was not in the scope, right? Was not acting as an employee in the course and scope that day. So that was in our lingo at our firm, that's defense lie number one. Number two was that it was self-defense, that the person, our client, was actually the one who was responsible for what happened, right? So that was, again, and using the word language we use at our firm, that was defense line number two. And then number three was basically our client wasn't hurt. And we were, I think, a bit more direct. We said, lie number three was our client was damaged goods. And that's, I think it's important to pause there and talk about the actual language and why that's important. Whether you're dealing with a case like this, a complicated med mal or product liability case, or just a run of the mill kind of car wreck case, right? The defense is never going to get up there and say your client's a liar. Your client just wasn't hurt, right? They're never going to do that. So I believe it's like our job as plaintiffs' attorneys to take their subtle, implicit arguments and bring them to the surface, right? So, for example, I've had the chance to represent a couple felons in personal injury cases, and the defense attorney is never going to get up there and say, you can't believe a word this guy says because he's got a felony conviction from however many years ago. So what is our job then as plaintiff's attorneys? It's to bring that to the surface, because of course the defense isn't going to agree not to bring that up in trial. Why? Because that's something that they want the jury to be thinking about. Can they trust this person? So I'm a big believer that it's our job in that case, let's say where you're representing the felon, in opening statement, that's your opportunity to say, I can tell you one of the reasons why we're here is because you're going to learn over the next couple of days that yes, that our client had a felony conviction. Yes, that they did their time. You're also going to hear that it's been 10 years since that, and they've built a business. They support a family. They do all these wonderful things in the community. And that the defense is going to tell you that despite all of that, that they don't deserve the same justice that you and I deserve, right? And so now we've taken what could be a weakness that we would have, at one point, I would have wanted to hide from and try and motion out and make it to some degree a strength, and to try and show the jury that the reasonable party in the courtroom is us, that we're here because of the defense and their unreasonable conduct. And so coming back to this case, we dedicated the last portion of our opening statement to that. And of course, that framework helped us, guided us throughout the entire trial. During our direct examinations, if there was opportunity, especially during cross examinations, we kept pushing this kind of theme because it was true. Ultimately, it was true, and we just had to bring it to the surface. I know I'm kind of on my soapbox right now when it comes to this, but I think it's very important. But one of the things that I learned recently to kind of reaffirm this approach is Gray and I were in Houston maybe a month ago at one of the Lanier trainings, and I remember Mark Lanier presenting, and he said there's 3 levels of lawyering. He says level number 1, your baby lawyer, you got your good facts, and you got the defense has their good facts, or otherwise your bad facts, right? And you just hope that the defense just doesn't do a good job, and you just hope that the jury just doesn't pay attention to those bad facts. He says that's baby level, that's level 1. Then you graduate to level 2, and then you just yell about your facts really, really loud, hoping to drown out all the bad facts. And then he says when you get to level 3, that's when you really got it. That's when you look at your facts, and then you look at your bad facts, and you make those bad facts actually your facts. And so that's, I think, what a lot of really great trial lawyers are doing around the country, and comes exactly back to what you said, Mike, about undermining the defenses from the start.
Yeah, no, it's interesting that you say that because, I'll talk to a lot of younger lawyers that haven't tried a case, and they'll ask me, what are your tips? And a lot of times they're trying a case because they have to, not because they want to. It's a tough case, maybe a premises liability case. And I try to explain, and you have a prosecutor background, right?
We all do. So
okay.
Actually, of our 5 lawyers right now, everyone was a prosecutor. And everyone was a former JAG. And then, we've got a kind of a unique group. We'll have 7 lawyers by September, and of the 7, 6 will have been prosecutors, and 5 have been former JAGs.
Yeah, so I think that's really good experience to have, because the advice I give is, you have to prove your case more likely than not. And a lot of times when you haven't tried a case, you go, okay, well, if I just have to get over the 50-yard line, that's not that hard. That's an easy burden to meet. And what ends up happening in the premises cases is there's so many defenses, pre-existing injuries, not that injured, contributory negligence, all these things. And you get so afraid as a young lawyer that you need to put all those things in context, that you need to address all those things. And you're told you can't wait until witnesses to get ahead of that becomes the opening statement, is explaining away all the defenses. But you got to have your foot on the gas. You need to be meeting your burden of proof beyond more likely than not, even though that's what the jury's going to be deciding. All the defense has to do is kind of get the jury to be in the middle. Right? They don't need the jury to buy into the defenses completely. They just need to drag you away from that 80% conviction mark. And then it starts to become murky. So it's really interesting that, Lanier has that category breakdown, because that's exactly my experience in talking to younger lawyers. It's hard to get that to click. You have to try some really hard cases to sort of see how it affects a jury when you get up there and you just explain too much.
Well, you can't respond, right? That's the thing. It's not about responding to the defense's arguments. It's about reframing and frankly using them as leverage. But anyways, it's something, I don't know. It's something that I think only recently have we put on paper and said, here's our framework. And it's something that's developed over time. And I would be lying if I didn't say this is stuff that I've learned from people all over, and what I've noticed too is you see people getting results over and over again. You start seeing kind of the same themes, right? And it's stuff we're talking about today.
I think kind of what Michael was hinting at too is that what you focus on is what you're telling the jury is important. And if here we get 30, 45 minutes for an opening. If you're talking for 10 or 15 minutes about your good stuff, and then the rest is about all the defenses and undermining them, cutting them off, you're signaling to the jury, I'm afraid of this defense and I'm not that, confident in my case. And I guess that kind of segues into sponsorship theory and the cost of who sponsors those witnesses and evidence. And I guess I'm curious, as far as you guys, it sounds like you have this 4-step process and you kind of address those at the last step of why are we here, and you're talking about their defenses and why it's kind of BS. Is that sort of how you guys structure it?
Yeah, and then Greg, correct me if I'm wrong, but I don't think in the way that it's presented, it comes off as we're really talking about their defenses. I mean,
Okay.
maybe to some extent, but we don't. I mean, it's not it's just, I don't know.
We try to make it more.
It's just a part of the story.
These are our facts as opposed to their facts.
I see. Okay.
Make them turn a liability into an asset, rather than being on defense.
Yeah, I think that's right. And I'm sure it's nuanced. I'm sure it depends, but we don't want to ever be in a position where we feel like we're explaining. Or explain, that might not come off right, but feel like we're responding. Well, the defense is going to tell you this, but guess what? You need to consider A, B, and C, right? It's more of attack mode. It's more of we're here because they think this felon doesn't deserve justice like you and I, just even though it has nothing to do with it, right? And so I recognize that might be just semantics to some extent, but I understand and I completely get your point about not wanting to make the vast majority of your opening explaining away the defenses, right? Because to your point, what we choose to focus on is what the jury chooses to, or not necessarily chooses, but may very well lead to what the jury spends the most time or gives the most credit to.
I'm curious. I know, I've watched a lot about the verdict, and any great opening is also a simple opening, and it makes it very easy for the jury to unpack what the case is about and understand the meaning behind the case. When it comes to your preparation and iterating on the opening, how do you accomplish that? Are you practicing in front of the firm? Are you scripting it out and refining? Everyone's kind of got a different process, but I'm curious how you guys do it.
It's a team, so it's without question a team approach. So, and I don't say that just to say, oh, no, it genuinely is, and it generally was for this opening. I mean, because the opening statement for us is the entire case, and so everyone needs to be bought into what it's going to be. It years ago, you would have found me doing more rehearsal type stuff. Nowadays, not so much. Not to say that maybe I shouldn't be doing more of it. We use a slide deck. We make sure it is very simple. And then as we're like working together, I mean, and we're making changes in the days, weeks before trial, sometimes months, right? And we get to a point where we know enough about what we're trying to do. We're so confident that we don't need a script. Like we don't need, the outline is the slide deck. And we know we're so wedded to kind of our 4-question framework that we kind of know what we're going to do. So I'm not trying to say that we don't practice. We certainly like run through it, or are very critical about what we're going to say, what's going to be in there. For this case, I mean, Nathan and Zach presented it to our firm. Gray and I had something, and they kind of focus grouped it to our firm. Occasionally we'll do these things in focus groups, not always. But it's not the point where we're again coming out with a script. It's coming out with the deck, a slide deck, which serves as the outline, and knowing and just having enough conversation and knowing what we're trying to achieve that allows us to go out there and get it done. And also another thing is, opening statement is just a part of the conversation, right? And what do I mean by that? What I've learned in the last few years is that a trial is really just a conversation. It starts in jury selection and it ends in the deliberation room. We just don't get to be a part of that last one, right? And so what we've done is opening statement will change depending to some extent about how things go in voir dire. Like not necessarily meaningfully, but it's not uncommon for us when, let's say, there's a juror that we learn in voir dire who suffered from a serious car crash, but maybe it hadn't, it was serious and it was a T-bone, for example. Maybe an opening statement when I'm up there and I'm explaining this crash, I'm addressing that juror and I'm saying, and ma'am, it's not like the one that you endured, right? And so it's a conversation. And I'm not trying to say that in a way of, oh, you just kind of figure it out. No, it's something that once you're comfortable enough and know the direction you're trying to go, and your team has worked together and you have a plan and you've got the slide deck to basically use as your outline, you're ready to go. At least that's been our approach so far.
Yeah, it amazes me that there's still lawyers out there who are typing or writing their whole opening and then just go up there and read it. And, you know, we find that a lot with the defense lawyers where they just like come up with a notepad and they're just like reading this thing to the jury, and it's so boring and it's not spontaneous at all. And I think they lose so many points by not just being in the moment and being able to have the spontaneity that I think the slide deck, PowerPoint, whatever you call it, gives you, because you're just talking. Like you're just, here's the next slide and here's what we're going to talk about, and it's more natural versus like being tied and looking down at your paper. It's just so.
And that was me at some point. I used to do that. I mean, I think we
all did.
We all.
Well, yeah. I think that's why Courtroom View Network and Trial Lawyers University are such important assets for our space, and they've really, I think, upgraded the skill sets that people have. Because as a young lawyer, I would go to the courthouse and I would sit and I would watch trials. And guess what? Both the plaintiffs and the defense lawyers were doing the same thing. They were getting up there with a notepad, they were reading the script, and they were looking up occasionally. Yeah. There wasn't a lot of use of PowerPoints. There wasn't a lot of use of demonstratives. There was no real command of the courtroom with their bodies, their voice as a tool, none of that. The first time I ever really got exposed to that was Trial Lawyers University. And of course, you know, Bob has told me back in the day, I mean, I actually got started reading All on Damages, and there literally is a script in it, which I think is based on Keenan and Reptile. And I think there's some good structure in there, but the idea that you're just supposed to copy and paste and put in your facts, and I mean, the industry and our space has come a long way since I think COVID and TLU in understanding that to really resonate with human beings, you have to be a human being. You can't get up there and be a ChatGPT lawyer.
That's it. And part of that is like Sharif said, it's having that conversation and having the framework and knowing your facts. You've got to know the case, of course, really well, but being able to, judge from the facial expression of the jury, something that's landing, something that's not landing, maybe something needs to be explained or something can be skipped over. But really, engaging in that conversation and having that slide, that PowerPoint is really just your loose framework.
I wondered how you get there. For me, it was like, and I mean, I'm without question still a work in progress in every aspect of my life. But I wonder. I mean, I remember going to the ranch for the Jerry Spence stuff, and I don't know if that was it. Maybe I'm sure it helped, but it was like, all right, get up, go, do your thing, right? Like there was no preparation, like, and that I think that gave me a lot more confidence to realize, you know what, like if you know your case, you know that all you have to do at the end of the day is tell the right story and connect, right? Then you're better off. Not to say that all the prep work and knowing your facts and framing all that stuff is important. It's still very important. But I think we're oftentimes we use the podium, we use scripts as like a crutch, and and it actually interferes with our ability to connect. And the connection, I'm sure you guys both know, is far more valuable than the words coming out of your mouth.
I think it goes back to what you were saying before, is like, you as a lawyer going to law school, you want to, right, you're taught to identify every single issue and address it. And so there's this element of like perfection that we want to have. We don't want to miss anything. And so I think when you're a younger lawyer, you want to write it down and read it, because you don't want to miss one sentence out of that opening. Whereas once you've done it a couple times, you realize, well, it's okay to miss some things in the opening as long as you're connecting with the jury and you know what you're talking about. So I think that's one thing, is just having the confidence in yourself that you know the case, you can go talk about it, have the conversation like you said. And I think also, just like you said, getting up and just practicing, whether it's, Jerry Spence method or doing your own focus groups, but just talking to people, because you don't want to go in there for the first time and like do your opening in front of the jury. You should, be practicing that so you're comfortable and you're confident. That's, that's the importance of doing those focus groups.
Absolutely. There's another part is like the note taking. Like we've stopped that now too. Like we don't take notes, which I know sounds insane, but like I remember early on after law school, it's like I'm trying to write down every word, especially like, have you ever seen the people, and I was one of them, like cross-examination, you're getting ready for a cross, so you draw the line down the middle of the piece of paper, and you're taking notes, everything they're saying on direct, and then you're like trying to like think about how you're gonna go on cross. Like I'm sure I did that a handful of times. Now I'm at the point where like almost zero notes, like almost, because you're not listening. And if you're taking notes, you're just not listening, you're not there. And so that I think has also helped as well. But I mean, I don't know if I wish there was a magic pill that helps people get over it and then just be themselves right in the courtroom. But I think maybe just the reps, getting the right training and the experience of like seeing it work, right? Like it can be very empowering.
Yeah, I completely agree with that. You were asking, where does it come from? For me, it's how can I be confident if I don't have the evidence that I can do it? I think you just have to put yourself in the arena, go try a case, take cross-examination 10, 15, 20 times in trial, do a great, do it a poor job, do an average job, do a better job, and start to get off your outline and be comfortable with the idea that you are enough, that your mind is enough, your preparation is enough, you know the case well enough to just go up there and get the testimony that you need. Curious, just circling back to focus groups. I know when we were in LA at Outer Realm, we had a conversation about focus groups, and I know they were important in how you viewed this case and how you worked it up. Can you speak a little bit about that and how it plays into the way that you frame the opening?
Yeah, so we presented this case originally in a focus group. I believe it was like early December. The case is tried in February. And it was one of three different cases we put in front of the focus group. And when we do focus groups, we do it probably a little bit differently than others. We present it as though we've been hired by someone. We don't disclose who. That we've been hired and as this sort of third party. We're just presenting the facts to the jury and getting their input and getting their feedback. And so we presented two other cases, and then we presented this case. And at the time, we just had one attorney really working on the case. We'd recently had Nathan Hiddle join us from the Commonwealth Attorney's Office from the city of Richmond, and so he was going to be joining us on the case as well. Sharif wasn't even assigned to the case yet, but we presented this case to the focus group. We showed them the video of the assault. We talked about the breach of trust, and I remember very clearly the focus group members. And at the time, we had asked they asked, well, what's the plaintiff asking for? And at the time, we said $8 million. And I remember one of the focus group members just very sort of cavalierly saying, well, then give them that. Just like, whatever they're asking for, give it to them. And so that, at that point, we sort of realized, because I think there was another case that we were presenting that we were maybe a little bit more, we thought was a better case because it had the sort of, stereotypical economic damages and physical injury and all these other things that we were experts and all the stuff that we were lacking, on paper with this case. And it really just sort of kind of awakened everyone. And from that point, the decision was made, we want Sharif jumping on this case. We want Nathan, he's just joined the firm, we want him jumping on the case. We want Zach to continue what he's doing. I'm going to be involved. Basically, we just made the decision. We're all piling in, and we're going to just give this case our full effort. And so it was definitely opened our eyes for the good. Then maybe you could talk about from the focus group how that affected our framing. I think that was part of the question as well. Right.
Yeah, I mean, it helped us answer those questions, right? Like, why does the case matter to the jury? Well, I mean, the answers from the focus group were pretty obvious. It was, this could happen to anybody, right? This could be a loved one. And as a parent, you drop your kid off and you have certain expectations, right? And so the community shares those expectations. And obviously those expectations weren't met with what happened here. The betrayal of trust, right? I mean, all of those things. And Zach and Nathan did a really good job with the focus group remaining neutral. And what's cool, we can test it too at the end. I know you guys run a lot of focus groups. I'm very envious of your new courtroom. It looks awesome, by the way.
Thanks.
Yeah, it looks awesome. But we do a test at the end where we ask, like by survey, like who they thought we were hired by. And I don't know what the breakdown, but it's been pretty good so far. It's like defendant,
typically more defendant and insurance company than plaintiff.
So, which is good because then we can actually to some extent rely on the output, right? Because as you all know, garbage in, garbage out. But no, I mean, the focus group helped wildly because before the focus group, we thought there was value. I mean, there's a reason why we worked, or Zach spent so much time in Gray working the case up, but we didn't really know. And that opened our eyes.
I'll even add the members of the focus group saw some things. We've been working on the case for so long that you kind of become blind to some things. Maybe you think some facts are stronger than they really are. And maybe you just overlook some facts altogether. And one thing that struck me in the focus group is that members of the focus group were watching this video. And this really kind of helped with framing. They're watching the video and they're not only, you're drawn to our client, you're drawn to the employee who's dragging our client across the floor of the dormitory. Well, members of the focus group, they watched that because they were shown the video multiple times, but then they looked at the other kids who were in the dorm at the time. They looked at the coworker who was there, and they looked at their body language and they said, And they came to the conclusion, like, this happens on a regular basis. This is not some one-off and people are just taken aback. They seem very nonchalant in terms of like watching this unfold. And even as the young boy is being deposited out into the hallway, one of the coworkers goes and opens the door for her. You know, and it's almost like it's this. And so from that, the focus group just took this. Just had it was just like this light bulb went off after watching the focus group of just how this is sort of institutionalized. This how it became bigger than just this employee, this rogue employee, because the defense wanted to say, well, she wasn't within the scope of employment. She's rogue. She's doing all this stuff on her own. And it's like, no, this is how they do things there. And so I think it really helped us with framing as well. And so with the focus group, I'm sure you guys have the same thing. When you run focus groups, you might learn something that you just completely missed, or they might talk something that you're not even thinking about.
Because when you guys were talking about framing the trust betrayal, I think, you're looking at this employee who's dragging the kid, and the thought is, oh, this person did this and it's horrendous. But in order to really get to the, liability on the corporation, you got to frame it in a certain way, whether that's, lack of staffing or training or whatever it is. How did you guys figure that out? And who did you really focus on as the person who betrayed trust? Was it the employee? Was it some management, the corporation in general? How did you end up framing that?
It was the institution, and it was layered, right? Layered in the sense of like, this isn't supposed to happen at a place like this. There was promotional videos they had on their website Nathan found that showed that their message, at least to the public, was the exact opposite of what happened to our client. And so there was that kind of hypocrisy there. There was the spoliation of evidence, the loss of the video, right? That's kind of a betrayal. So it was, we're big believers in like, sure, did we go after the individual? Yeah, but it was about the institution for the most part. At least that's how our case was focused. And of course, the defense helped us, right? In the sense that they made these arguments saying that like she wasn't in the scope, right? And that they didn't preserve video that because they made the decision that it wasn't relevant, right? We didn't actually ask for the instruction on the spoliation because we didn't want to create an appellate issue potentially. We fought for like crazy prior to the trial and then during the trial, and we got leeway to pursue that inquiry during trial, but ultimately we never asked for the instruction, even though I think we would have gotten it. So there was a lot of layers to it, but to answer your question directly, our focus primarily was on the institution, because there's that, what is it, and I may be making this up at this point, but it's the Jerry Spence quote where it's like, you play with a mouse, you don't kill it, or something like that, right? And maybe, who knows where that came from, but it's the idea that if you go too hard on an individual, you can actually start doing damage to your case, because then you
turn the jury against you.
Exactly, right? And then something like, oh, well, they're not that bad, or oh, well, man, they didn't deserve that, right? And I'm sure anyone listening to this can think of that in real life, where somebody went really, really hard on someone who normally 9 times out of 10 they'd say, screw that guy. But because of how hard they got beat up or for whatever reason, they're actually like somewhat sympathetic to the person. So whereas institutions, less hard to do that. Now, one of the things we did have to think about in the framing is that, and we had slides to this point, is that, this is an institution that does otherwise fantastic work, or at least takes on an incredible challenge. Dealing with children who have just very, very, very difficult situations. And so the way that we approached that was not to vilify this institution as they're evil. We said, you know what? Good corporations can make mistakes. What matters, though, is what they do in response, right? And so that's kind of how we got in. Actually, that was our segue from question 3 to question 4.
That's what's so interesting to me is, from the defense's angle, I would think they would be focused as much on the institution as you were, just in a different light. I would think that they, and I'm sure they did, leverage those videos on their website saying that's not us. There's a right way to do things. There's a wrong way to do things. We do things the right way. This employee who was acting outside the scope, did it the wrong way. But what's so interesting is they lose so much credibility from going from that argument to, and he's not hurt that bad, and he was damaged goods, and all these other weaker arguments, but they just can't help themselves. And that's what's so interesting, is that war of right and wrong and focus on the institution is so often lost by the defense simply because they want to have their cake and eat it too, where I think plaintiffs' lawyers are much more strategic and aware and conscious of the fact that you have to simplify things and you have to have a very clear theory of the case. And when you spread it wide like that and you try to go from all these other angles, the jury doesn't buy it. So that's interesting that you guys had that approach. Did you see that in the trial? Were they using those videos to their benefit?
I don't think they specifically use the videos for their benefit.
I feel like they raised every possible defense that they could. Yeah. It was a kitchen sink approach where if they could, in good faith raise a defense, they did it to the point where it was overkill. And definitely they were on the defensive the entire time. And it's kind of like, so just because you can make an argument doesn't mean you should. And I feel like they made every possible argument. They left no leaf unturned in their approach. I think that ultimately worked for our favor.
Yeah, our case got stronger during their case, I thought. Now, granted, they made an offer, a lower offer, as the case went on. So we didn't know how things were going. We thought things were going great. And they're like, they've got insurance observers in the back and a few lawyers, and they're making an offer that's less than what it was before trial. So we're like,
oh, wow.
Yikes. So we didn't know what was going to happen. I mean, and it was kind of twisted to think like that we're all watching the same thing. Actually, isn't that ironic? Yeah. Like they were going full circle talking about the football thing, right? We're both watching the holding call and we're seeing completely different worlds.
So they seem to want a verdict as much as you guys did.
Yeah.
Yeah. They were sure
they'd like to have that one back.
Yeah. So, but no.
Interesting.
I was very proud of the result. It was like, without question, an awesome team effort preparing for it, even like during the trial, and also having the experience with prosecution because they're on our group. Like we could huddle and let's say a piece of evidence they were trying to put in. Yeah. Could we have objected on hearsay grounds? Sure. But there are times we took 10 seconds, looked at the thing and we're like, let's let it in. We got something here. And so those strategic calls kind of in the spur of the moment went our way a lot too. And so anyways, it was a really, really cool team effort. And it's really neat to have done such great work for a client and to get a jury to make a statement like that on behalf of this child. And then two, also to show like, this is possible. I mean, people looked at us like, and still are looking at us like we're crazy, right? Like, how do you do 4 lay witnesses, no medical bills, no expert, none of the traditional markers, and get results like this? And it's not magic, right? It's really just taking a step back and looking at the truth and being simple in our approach and disciplined and saying this stuff matters. Things like trust matter, dignity matter, hope matter, and they matter a hell of a lot, right? And so to show others that this can be done has been really cool.
Yeah, absolutely. Yeah, and we talk about that in our firm too a lot, that, this traditional view of looking at how much are the medical bills and did they have this surgery or not, or that kind of stuff. That's like the insurance company's evaluation, and like what you said about the emotional things, the underlying things, and you don't need a lot of it. You don't need to like beat a dead horse. Like you get a couple of things in and that's all you need. You don't have to have all these medical bills and appointments and treatment. Like it can be pretty simple, at the end of the day.
Yeah. Yeah. And we, as kind of to the point you made earlier about the sponsorship theory, we get to choose what the case is about.
Yeah.
Right. So if we make it about medical bills, then everyone's going to be focused about billing codes and stuff like that. So no, but which is also one of the cool things about this job is the creativity and the autonomy that we have and being able to kind of frame and pursue our cases.
Well, and that reminds me, and Michael, tell us what you think of this, but I think the medical bill thing and the records and all that stuff it just deflates the whole energy in the case. And it's, now we're talking about this and in these documents, and there's nothing lifelike about that stuff. There's no story, there's nothing to it. And
well, and the acre is real. Actually, Greg, you want to tell them about the Atkins and Papa Cable?
Yeah, so we've run focus groups. And I think it's one of those things in terms of the medical bills, where as lawyers and also dealing with insurance adjusters, insurance companies all the time, everything is through this lens of what are the medical bills, what are the specials, what are the economic damages, and so you automatically assume that a jury is going to look at the same thing and they're going to magically know to apply some factor, some multiplier to that, when really they're not looking at it all. But yes, we've done multiple focus groups, and we've even run the we had two cases where we did a focus group side by side, and they were, for all intents and purposes, very similar cases. They're both slip and fall or trip and fall type cases. With one was really orthopedic injuries, another was brain injury. And with the orthopedic injuries, the medical bills were, say, like $300,000, or pretty substantial medical bills. Whereas with the brain injury, there were some initial treatments, some CT scans, things like that. But relatively, there was not so much that was done. But really, with the brain injury case, we're focusing on the effect on the quality of life and this and that. And with the but we presented the medical bills and sort of we talked about the quality of life and all those things as well. But ultimately, we presented to the focus group. One focus group gives the woman who had the orthopedic injuries just a little bit more than what the medical bills are. Whereas in the case where no medical bills were presented, the brain injury case, I think it was like
15 to 200 million.
Yeah, 15 to 200 million. And it's just like cases that were, yes, they're different in terms of orthopedic versus brain injury, but like they weren't that different. And, we also just did a focus group recently where we had previously presented it with medical bills. And then, we're kind of up for trial soon on this one. And this time we did not give any medical bills. I think it's probably between $60,000 and $90,000 in medical bills in this case. And the numbers that the focus group came back with, 10 times as much when no medical bills were given versus medical bills presented to the focus group. It's just, so the anchor, so our default now is kind of like, there has to be some pretty compelling reason for us to put in the medical bills or the specials in general.
Yeah. And then, it almost like helps us come back to like the true goals of these cases, right? Like if we think about like what are our clients' goals, and we've kind of distilled them into 3 parts. It's one, they want, when they walk into your office, or when they zoom into your office, right? Because nobody actually comes in person anymore. But 1, they want accountability. 2, they want this to not happen to anyone else, especially in their community. And 3, they want some recognition that what happened to them had value. What was taken from them had value. Medical bills is not in that conversation. So it's no surprise that when we as attorneys take a step back and throw away the insurance adjuster spreadsheets, right? Like suddenly, like we're actually speaking the exact same language that the jury is. Because they're not looking at they're not coming in with this preconceived notion of some factor of this arbitrary number for special damages. I mean, they're thinking the same things, right? They're thinking that these things like trust, dignity, hope, autonomy, safety, health, whatever, right? That stuff's important, and it has real value, so much more than what a medical administrator decides to charge somebody for a knee surgery.
Well, that's what's, it's funny because there's a lot of people in the plaintiff's bar, a lot of trial lawyers that agree and think the same way we do. And then I'm sure that, through your own plaintiff's bar, or just talking with other lawyers, There's some lawyers that are just unsure, or they're just adamant, like, you can't waive specials. Like, that's just the wrong strategy. It's the wrong thing to do. The case is, it's an important part of the case. And what I always say, to your point, Gray, is like, first of all, stop drinking the defense's Kool-Aid and realize that you're doing that. But don't take my word for it. Okay. I'm not here to preach and say you got to do it. Go test it. Like, go test it in front of a focus group. Go test it in front of a jury, and you'll have your answer. There is a right or wrong answer to this. And so we don't have to debate about it. You can just go see in practice that as soon as you anchor them on the medical bills, that is what the case becomes about. And yes, there are exceptions, but generally, I think if you test it in a focus group on any kind of case, most of the time you're going to see that the case has a very different value if you introduce the bills.
You know how it really works is when you waive your medical bills and then you see the defense trying to put them in.
Oh yeah,
That's how you know it really works.
After you've done request to admits on them and they deny it, then they want to bring them in.
That's
all
right.
of a sudden.
I want to end with this. This has been an awesome conversation. I want an answer from Sharif and Gray as well. With every trial that we do, you work on it sometimes for years. I don't know how long you guys were involved in this one. And it's almost a spiritual experience. It is a spiritual experience, going to trial, going into the arena and getting justice for your client. And you always step away from it and you have a different perspective, no matter what, whether you win, whether you lose, no matter how the trial went. There's certain things that stick with you. There's certain things you change about the way that you see cases. I'm curious from this trial, I'm sure there's many, but what's the first thing that comes to mind about this trial that sticks out to you, that changed your perspective on how you see cases, work up cases, anything that comes to mind?
I think it was very affirming for me as to like how we prepare cases, and also I think really when we sort of adopted the team approach of really pouring everyone onto into the trial and sort of divvying things up, and going forward, we're sort of using the same approach in terms of how we're dedicating our resources for trials going forward. I think it was just very affirming for me to see like the things that we're doing and to see that the things that we're talking about, putting them into practice and seeing them come to fruition. I think was just it was incredibly rewarding.
Yeah, love that.
I think on my end, I agree with Gray and without question affirming but as a firm and then also on a personal level, like, we know what we're doing, we can do this. Kind of coming back to like, this stuff matters, right? Like the value, as corny as it may come across, but like the value of human life matters. The value of these intangible things like trust, hope, dignity matters, and it's significant. And so being able to go, and it was a ton of work. Zach and Gray spent countless hours working the thing up, and then the trial team spent tons of time in court on hearings, fighting for. We filed a 15-page motion to reconsider of voir dire questions that were struck the Sunday before trial. Just tons and tons of work. But to know that if you and your team are willing to dedicate the time and the resources, and are also willing to go out and get the education to do this stuff right, you can make a big difference for the people you represent, a big difference for the community, and really send a message that this stuff not only can be done, but is important and should be done. And so it's given us a lot more, I think, confidence to look at our cases in a certain way, to continue to study, to travel. We were at Mitnick's thing last week. We'll be at TLU in a couple weeks from now. Continue to try and learn, because the more that you invest in yourselves and learn this craft and get out there and, to your words, get in the arena, just the more opportunities to do good there is. And so anyways, really proud of how our team put this thing together and got the result, and excited for the next one for sure.
No, yeah, it's a phenomenal verdict. And, whenever you see big numbers, right, a lot of hard work went into it. It's a great result, but every verdict is not the same. And real trial lawyers, they know that. And the facts of this case, the fact that 3 other law firms turned it down, it's really our duty as trial lawyers, isn't it, to be doing these focus groups, be doing the work, taking these cases to a jury and having them put a value on it so that we can say, maybe we're wrong. Maybe we do have an inflated value, or maybe the mediators and defense lawyers and insurance adjusters are the ones that have it way wrong. And isn't that our job to set an appropriate, reasonable, and fair benchmark for what these cases are worth?
And you're
Thank you,
not gonna find
guys.
that on a listserv, right?
Right. No, well, and that's why I think these conversations are so important. These verdicts are so important. There's a lot of different perspectives in the space, but results don't lie. And juries are the ones coming up with these numbers, not us. So we might be saying it 2 years beforehand to the mediators and everyone's saying we're crazy, but it's juries, human beings that decide these cases that are saying, no, this is fair and this is reasonable and this is what it should be. So thank you guys for all the work that you put into this case and for having the courage to go and try it when all these other law firms turned it down, knowing you could lose it, knowing it was a tough case. And I'm really excited to spend more time with both of you out in California. It'll be a good time. So thanks for coming on the pod, guys.
Yeah, thank you guys.